the claim has been struck. There will be no consideration of it on the merits. So there will be no decision as to whether or not the circumstances, aggression by a foreign state, constitute civil commotion, so that the government can pass regulations restricting freedom of movement in terms that it did. Clearly the court didn't consider it important enough to determine and didn't think that it was very likely that it would reoccur so as to merit a reconsideration of the issue.
He said the court does not make academic differentiations or academic determinations, Was the P.U.P. foolhardy to have brought it in the first place, knowing the extremely tight window?
No, what it is there is no absolute rule that the court does not entertain academic matters. There's a discretion to entertain it. And what we said was that this matter was of sufficient importance for the court to proceed, notwithstanding that it was academic. There's a difference. So there is no absolute rule that once it was academic, and it's academic because the regulation itself has been revoked. There's no continuing breach of any constitutional right. But there was still the issue of whether or not, while the statutory instrument was in force, whether it breached constitutional rights to freedom of movement. Difficulty is that you're talking about 20-odd days and no real harm being caused to anybody. So that, in a sense, in a very real way, it was academic. But we thought, and we've thought from the beginning, that the issue was one of sufficient importance that warranted a decision from the court. Clearly, the court didn't think that it ought to use judicial time to do this, that it had a sufficient level of importance. And I don't know that the court was not justified in so finding.